Greetings all fans, thanks for joining me today on my video blog. Today we're going to talk about what a personal injury attorney does for his clients. In particular, this personal injury attorney. There are a few different stages of my representation. The first stage is the claim initiation stage. That's whenever we contact the relevant insurance companies and let them know that a claim needs to be set up and they need to investigate it. And we determine what coverages may or may not be available. Generally, we're talking about liability coverage. That's the coverage in an auto accident, particularly for the at-fault party. You might also have medical payments coverage through your own insurance policy. In some circumstances, you may need to access uninsured motorist or underinsured motorist coverage. And so we'll explore those options for you and set up those claims as necessary. Another little tidbit that will come up in that initial stage of my representation is we'll discuss whether or not you may have what's called a diminished value claim. In that situation, your car will not have been totaled, but it will have been damaged. A certain amount of repairs will have been done. And if it's a relatively new car, then a significant amount of diminishment in value may have occurred, and you should have a right to seek recompense for that. So that's what we'll try to do, get that claim set up as well. The next stage is the treatment phase. Now, that's mostly where you're doing all the work. You're getting better, you're seeking out health advice, and you're doing your best to get better and reach what we call maximum medical improvement, meaning you're as good as you're going to get after the accident. Some people have the impression that their personal injury attorney is going to tell them what doctors or what healthcare providers to go to. I am not of the opinion that that's necessarily appropriate. I tend to shy away from recommending one provider over another because I don't want to be seen as sort of being in bed with one provider or another. My job, though, is to educate you as to what healthcare decisions, what the effect of those healthcare decisions might be on your claim itself, not to make those healthcare decisions for you. Your health is your concern, and so I want you to make those decisions, but I want you to make them in a way that is educated towards how those decisions will affect your claim. So that's my job, to help you do that. Once again, when you are deemed to have reached maximum medical improvement, meaning your healthcare provider feels you're as good as you're going to get after the accident, that's when we feel like it's time to start moving forward with your claim and reaching the next phase, which I call the documentation phase. At that phase, the claim is ripe to get all of your records and bills together related to your medical treatment. There will be some other documentation in some cases that we'll need to try to procure as well, particularly lost wage documentation from your employer that is going to document how much in wages you've lost as a result of your injuries. Oftentimes you're the best source of those lost wage documents, meaning you're the person most able to get those documents. In other words, if I contact your employer, they may not be likely to provide me with that information, but they'll provide it for you. In certain circumstances, that's not the easiest thing to do, and I can coach you on it. Or you may not have an employer, you may be self-employed. In that case, I can help coach you as to how we can document a lost wage claim for your particular situation, if we can. The next phase is going to be the negotiation phase. After we get all of those documents together, we'll put together what's called a settlement package with a demand letter. I think demand is sometimes a little stronger word, and sometimes I call it a settlement request letter, but it depends on the tenor of the discussions between me and the insurance company. When we get that settlement package together along with the demand letter, you and I will talk about how I view your claim in terms of its settlement value. And I normally will have a ballpark figure of what I think the case might be worth. Now, the nature of our system is such that no one can tell you exactly what a case is worth. There's a great saying in our business, and that is, the case is worth what it settles for. And that's exactly right. Really only you can tell me what the case is worth, but I'll give you an educated opinion as to what I think a jury might do with the case. Particularly in light of what other juries have done with similar cases in the past that I've been able to find, or what other cases that I've settled or other attorneys have settled that were similar. We'll also take into account certain strengths and weaknesses of your case, and we'll talk about that on a case-by-case basis because every case is completely different. Now, normally, this is just because it's the majority of cases, normally we get cases settled. And if you're lucky, we'll be able to do that. And then we'll move on to what's called the settlement phase. Now, if we don't move on to the settlement phase, that means we need to talk about litigation. Now, that's a completely different video and a completely different topic altogether. It takes a long time to discuss. So just for purposes of doing the lowest common denominator, because most cases settle, we'll talk about the settlement phase, which, knock on wood, will be the last phase of the settlement. of the representation. Assuming we reach a settlement number, and we all agree that the case should settle for that, then there's a bit of documentation that has to occur. Normally the insurance company will send me a release and a check. The check will be a two-party check made out to you, the client, and me, the attorney. In that situation, we will get you to sign the release, which should say that you're not going to sue anybody in relation to this case anymore, and I'll go over the release to make sure that it doesn't say anything really more than that or anything more than it needs to say. Also, the two-party check, you'll endorse the back of the check. I'll run it through my trust account, and about a week later, normally that check clears, and then I'll be able to do the disbursements, assuming we have all those numbers together. What I mean by that is two things. One, when the check clears my account, that normally means the funds should be available from the insurance company's account. Insurance companies have bounced checks to me before, so you have to wait. You have to be patient because you just never know for sure. The second thing is that when we do the disbursements, we have to have accurate numbers as to what we need to pay out of that settlement check. The settlement will take into account the attorney's fees, any healthcare reimbursements, reimbursements we have to make to your health insurance if that's applicable, Medicare, Medicaid, those sorts of things. So we'll need to have all those numbers together. When we do that disbursement, you will get a disbursement form that will indicate how much money came into my trust account that was designated as your money, and then how much money came out and how it came out per check number to the recipient and so forth. So in the end, you'll see how much comes in and all that comes out, and there you go. So it should be zeroed out in the end, and then you'll sign off on that, assuming everything's right, which knock on wood, it will be. So in a nutshell, that's what I do for all of my auto accident clients. If you have an auto accident case, I hope you talk to me. So give me a call, 919-929-2992. Once again, thanks for joining me on my video blog, and hope to hear from you soon. Thanks.